Probatus, or as we know it, probate. What is it and do I need a lawyer? My name is Kerri Thomas and I'm a solicitor here at Clarke Hemmerling Lawyers. In South Australia, passing down or bequeathing property is governed by law. There are certain steps and disclosures that must be made about the deceased person's assets and liabilities. When a person passes away and leaves a will, probate is a process required by the Supreme Court to validate the contents of the will. It literally means to probe the estate and undertake an official testing of the will. It is an important test to ensure that the person's final wishes are followed, the assets of the estate are protected along with the beneficiary's interests. Many entities require probate to be obtained before they will release funds back into the estate. For example, banks, superannuation funds, residential care providers and land services SA in relation to real property. As estate lawyers, one of the most common complaints we hear from executors is the difficulty organising the varied requirements and the forms they need to complete as a step in seeking information to apply for probate. The executor is responsible for making an application to the court for probate, and all the information that is contained must be recorded accurately with all the assets and liabilities of the deceased, and the original will and death certificate must be lodged with the court. Court rules must be followed to prevent lengthy delays, and once submitted, a probate application cannot be changed or withdrawn. Lawyers tip: if you're an executor and handling the original will, do not undo staples to copy or to restaple it or pin or attach anything to the will, as it may affect the integrity of the document. Once probate has been granted, the executor must again write to the different entities, enclosing a suite of certified documents and relevant authority forms for account closures and the release of estate funds. When using a lawyer, all estate monies can be paid into the firm's trust account and held until the final distribution, which many executors prefer, so that they are not personally responsible for handling the estate funds. Do I need to appoint an estate lawyer? You do not need a lawyer to administer an estate or apply for probate. However, it is common to appoint a lawyer to assist due to the extensive work involved and the skill required to understand the paperwork for the court. Estate lawyers have streamlined systems and are authorised to certify the required documents. A probate application will usually take 6 to 8 weeks for the court to process if the application is correct and has been submitted according to the court rules. If not, this will contribute to delays in probate being granted. The law allows an executor to appoint an estate lawyer to assist with the probate process and distribute final estate funds to the beneficiaries according to the will instructions. Lawyers are often asked to step in if there is a conflict in the family or they have concerns they may be held personally liable to the beneficiaries if they get something wrong. If you're an executor of a deceased estate and are finding the process difficult to navigate or need help to apply for a grant of probate, please call and one of our experienced estate lawyers will be happy to assist you.